Hello and welcome everyone. I hope this message finds you fit and fine. We are in video number 46 of our Lakshmikant series Contest, and today we need to talk about governor. Part 6 we are starting today. We have completed part 5, that is union. It would be quite easy for you if you try to compare the dimensions which you have covered in President chapter. Since governor remain in news, saying that governor position has been misused by center to hamper the principle of federalism in Indian polity. UPSC has asked questions on governor in prelims as well as mains. So let's start governor. When we discussed the word parliament, so I told you that in parliament we include Lok Sabha, Raj Sabha and president, right? I hope you remember this. You remember this? Now, what about governor? So I told you why in the idea of parliament president is included, because parliament is there to make law, and there cannot be any law till the point president signs on that bill, right? It needs to be passed by Lok Sabha, Raj Sabha and then presented before president, right? Similarly, at the level of state, when we use the word state legislature, we have legislative assembly. In some states we also have second house, that is legislative council. Along with them we need to count the office of governor, then we can say that yes, this is state legislature, because bill is presented in assembly or council if there are two houses and then presented before governor. When governor signs, then it becomes an act in that particular state. So part 6, article 153 to 167, we talk about this state executive. Governor is the chief executive. It means all the executive actions of the state are taken in the name of governor. What does it mean? Many people have read this, but what does it mean? It simply means, consider a minister is issuing some policy, some directions. So on that file, the noting says that in the name of governor, such actions are being taken by state government, vetted by that particular department, and department head is, who is department head? At the level of minister, because policy actions are taken at the level of minister, right? Then implementation part is taken by the civil servants, right? So that is why governor is the chief executive head of the state, okay? Usually one state used to have one governor. But after 7th Constitutional Amendment Act, this provision was changed, and now one governor can be counted as governor of more than one state. Okay? A state executive consists of governor, chief minister. I hope you remember when we use the word union executive, I told you UPSC asked one question in prelims, that which of the following is not part of union executive, right? And one option was saying CAG, right? And that CAG was wrong. And some students were like, sir, how can CAG be wrong, because CAG is executive, right? But that is not correct in the definition of union executive that is mentioned in part 5. Similarly, when we are using the word state executive, so you should not say, sir, if I am posted as a civil servant in state government, it means I am part of this permanent executive, so why I am not being counted as state executive? You will be counted as state executive, but not state executive in the definition mentioned in part 6 of Indian Constitution. Okay, so this definition says governor, chief minister, council of minister and advocate general. And in the part 5 what we discussed, president, PM, council of minister and attorney general, right? Nominal executive head. What does it mean? It means real power remains in the hand of chief minister and the council of minister. Governor remains the nominal head. Along with this, governor acts as agent of central government. Now you may be thinking, sir, why central government needs an agent to be in the state? Yeah, this point was actually raised in Constituent Assembly also. Then decision was taken that we know that in India there's huge diversity, right? And it may be possible some states may have secessionist movement, because the size of states and the population we have in Indian state, we have less than this territory and less than this population, we have nations in Europe. So it may be possible some state get inspired, no, let's actually convert the state into a separate nation, and some of them will have chance to become prime minister, right? So we cannot allow these kind of secessionist movements in India, right? It could hamper integrity of India, and that is why it was needed that state government should work as per constitution, right? There is one rule book of the whole nation, fundamental rule book, that is constitution, and that is why who is going to ensure that in state, governor is going to ensure that in state. Now some of you might be thinking, sir, how can governor ensure that state government is going to work as per constitution when you have said that governor is just a nominal head, real head is CM and council of minister, real power is in the hands of CM. The reason is, the moment governor discovers that this state machinery is not working as per Indian constitution and there is no way out at the level of governor, then governor can actually recommend president rule in that particular state, and then president rule means now state government will not have say. Now that state is going to be directly ruled in the name of president, and now president is going to ensure that this state is going to run as per Indian constitution, right? So I hope you got the logic why we needed an agent of central government in state as governor. Now appointment. So governor is appointed by president. So do we have some election for governor? No, we don't have any election. Consider you are Indian citizen and you are above 35 years of age. We are considering that you are above 35 years of age, and your name is presented to Honorable President by Prime Minister. Prime Minister said, sir, this name Shashank Tyagi, we want him to be made governor of Uttar Pradesh. Then President will say, okay, take a sense, this name has been recommended by Prime Minister and Council of Minister. Okay, I am appointing that person, Shashank Tyagi, as governor of Uttar Pradesh. Okay, so this can be done by president. I am using the word pleasure of president here. What does it mean? It means my position as governor is not having some secure tenure. Although it is said that there is a 5-year, means once I am appointed and no one has removed me, no one means president has not removed me, then I can be on this position for 5 years. But this position is not secure. Any point of time, without any reason, president can remove me. It means I am there for the pleasure of president. Now you may be thinking, sir, president seems to have a lot of power. No, that's not correct. Actually, president is doing that, means appointing as well as removing on the recommendation of Prime Minister and Council of Minister. Okay. Now, what about oath? So Chief Justice or senior most judge of the High Court are responsible for giving oath. For that, you can just easily remember this. Yes, I think it is visible to you. Yeah. Appointment and resignation means resignation / removal. Means consider that governor wants to give resignation. So governor is going to give resignation to whom? To president. Okay. But when it comes to oath will be given by Chief Justice of that High Court, or if Chief Justice is not there, he may be busy, he may be ill. So at that point of time, the senior most judge of that High Court is going to give oath to the governor. So please remember this. These kind of facts are also asked by UPSC. I think this is clear to you now. Now coming to the conditions of the governor's office. First of all, he should not be a member of House of Parliament or state legislature. It means you cannot remain member of parliament or member of state legislature and simultaneously you want to become governor. Okay. Now I'm making a statement here and you have to tell me that statement is right or wrong, because there's a scope of question there. The whole thing is written before you. Okay, you can read it out and then answer me. Okay. So statement is, any sitting MLA or sitting MP's name cannot be recommended for the position of governor by Prime Minister, Council of Minister, full stop. It means it can be recommended only after resignation has been accepted of the concerned person from the House. Now tell me that statement is true or false. So those who are not able to concentrate on it, just pause the video, think on it, or just go back and listen to what I've said. I'm saying that consider you are an MP or state legislature, means member of state legislature. Your name cannot be recommended for the position of governor till the point you leave that seat. Some of you would say, sir, that is true. That is written here. He should not be a member of either House of Parliament. Acha. Do you think both things are same? No. Name can be recommended for the appointment of governor, even if that person is a member of Parliament or state legislature. But the moment that person is going to be appointed as governor, he will cease or she will cease to be on the position of MP or MLA. And that is what is mentioned here. Just read it. If any such person is appointed as governor, is deemed to have vacated the office, so then it will be considered that that person has vacated that house on the date on which enters upon office as governor. So it means it will be considered the date that person enter into office of governor. From that date it will be considered now this person is not member of Parliament or state legislature. So if you got it now, mention got it. Clear? Now, second, he cannot be arrested or imprisoned. I remember a case when Ms. Shreya Dikshit was governor of Kerala, and there was a CNG scam which was in news, and CBI was investigating. So now investigation was on, and CBI court was saying, and there were news that it may be possible that a direction for arrest may be raised, means conclusion, means proofs are of such level. But Constitution was saying something else. Constitution was saying you cannot imprison, you cannot arrest a sitting governor. Then what could be done? Considering the seriousness of that particular case, the concerned president, on the advice of Prime Minister, Council of Ministers, can remove that person from the position of governor, and then you can arrest that person. But till the time he or she is on this position, you cannot imprison that person. Okay. Along with this, any action which has been taken in official capacity for the official purpose, you cannot actually raise proceedings against that person, because that actions are having immunity. Why? Because most of the actions of governor are on the aid and advice of Council of Ministers, right? And if any action is unconstitutional, invalid, then court is there, na? High Court is there, Supreme Court is there. They can review that particular judgment, they can review that particular direction, they can review that particular order, and they can declare that ultra vires or null and void, right? But in case of civil proceedings, means after giving 2 months notice, civil proceedings can be instituted against him during his term of office for personal acts. So only for personal acts, civil proceedings can start. Civil proceedings means any matter with respect to tax, family matter. So those proceedings can start. Okay, but 2 months notice need to be given to the governor, so that governor can prepare and finalize all the pending works, responsibilities with respect to that state. That is why these provisions were added in our constitution. You should understand the logic. Now, when the same person is appointed as the governor of 2 or more states, what is going to happen? Who is going to pay the salary? Consider a governor is appointed for a single person is governor for Maharashtra and Andhra. Now, who is going to pay the salary? Now, you would say, sir, anyone can know. Both states would say, why we should pay the full salary, full allowance, when that person is also working as governor of other state. So now you should split the expenditure, right? Like you do in your parties with friends. Emoluments, allowances payable to him shared by the states in such proportion as determined by president. Now, the allowances, the salary is going to be splitted. Okay, it's going to be shared. That is correct. But please remember, UPSC can play on this. Who is going to determine what portion is going to be given by what state? This determination is not going to be done by one state or other, because they cannot agree on one thing, right? One state can say, sir, I'm a small state, why should I pay half salary? Other state is bigger state, so many cases, so many files, that state should give more. So that is why regarding this, that condition will be determined by president. Okay, there then can be a scope of question here. Please remember it. We are doing operation of every provision of this chapter. Now qualification. As I told you, 35 years of age and you are an Indian citizen, it means you are fit to become governor, right? But you need kripa of Prime Minister and Council of Minister for that. No education qualification is there, no maximum age is there. Even if you are 110 years of age, God bless you. If your name is recommended for the position of governor, you can be appointed on this position. Now, over the time, some conventions have been actually developed. Conventions means these things are not mentioned in constitution, but these things have been followed considering these are good. For example, if you take a look, governor of UP, governor of Rajasthan. So, governor of Rajasthan is actually a resident of UP. So, most of his life, active political life, he was residing in Lucknow, UP. So, he was appointed as governor of Rajasthan. Governor of UP, she was actually a politician, seasoned politician in Gujarat. So, the logic is that if a person from outside is actually appointed in the state, it is less likely that person will be considered as a political person, because governor position should be neutral. So, he should be an outsider who does not reside in the state where he will be appointed or she will be appointed. Another convention which was raised was that when you appoint governor, and since governor has to work in close tandem with the CM, then chief minister of that particular state should also be consulted. But this convention remains convention, matlab, this is not mostly followed, and that is why many CMs have raised this matter. But this convention is mostly followed. Okay. Now oath, I have already told you, oath, CJ or J. Now terms of office of governor does not lay down any grounds upon which governor can be removed. As I told you, if you are a governor of any state, say Maharashtra, and the next day you receive a fax from the president office that Mr. Rohit, from this date, now you are removed from the office of governor, you just pack your bags. So you cannot do any if and but. Why I am being removed? I'll go to the court. Then court will say, beta, you should read governor chapter from Lakshmikant, right? Because governor cannot question this, because governor position is there on the pleasure of president, right? And there are some cases with regard to this. National Front government headed by VP Singh in 1989. What VP Singh did? So he read this particular provision. He said, now I am giving a direction that Prime Minister is actually giving a direction. So Prime Minister cannot actually remove governors. Governors can be removed by President. Prime Minister can recommend President, right? So VP Singh asked all the governors to resign. That you yourself resign, otherwise I'll recommend to the President and President is going to remove you. So you should resign as you were appointed by Congress government. But after that, what happened? Eventually some of the governors were replaced and some were actually continuing that position. After that, when next government came in 1991, PV Narasimha Rao government, it means Congress government, then they changed 14 governors appointed by VP Singh government, Chandrasekhar government. So the point is that the central government removes governor from the previous government, right? And there has been question on this, that there should be some ground of removal also. Then only governor will actually act in neutral manner. Some of you would say, sir, what is the harm? Just remove them. What is the harm? Harm is that if governor knows that I have to be in good books of the Prime Minister and Council of Minister of the Union, then what they can do, they can actually misuse this provision of Article 356 of Indian Constitution, means President rule. Means if the party in power wants a different party's government in state to be quashed, so they would like to actually install a governor who is going to actually dislodge that government. So that is why Article 356 President rule has been misused many times, and governors were misusing them for their own security, because they wanted to remain in this position of governor, right? President may transfer a governor, appoint to one state to another, right? Further, a governor whose term has been expired may be reappointed. Now, my question is, consider you are a governor and you have completed 5 years there. Now, can you be reappointed in the same state, or you need to be, if you are being reappointed, you need to be reappointed in different state. Since our constitution is not saying anything about it, that is why you can be reappointed in any state, in the same state as well. Okay, please remember it. You have to read between the line. Okay. In case of the death or sitting governor, who is going to be working as a temporary governor? Chief Justice of that High Court is going to be appointed as temporary governor for that time by the Honorable President. Please remember it. Okay. Chief Justice of that High Court. Now, coming to the power and functions of the governor. Let's simplify executive power. You can easily remember these power by understanding this logic. Executive means implementing law. For example, there is a law regarding appointment and governor is just following this law, executing this law. It means this is executive power of governor. For example, appointing chief minister, council of minister, appointing advocate general means topmost legal officer of state government. So these appointments are done by governor and these come under executive power of governor. Along with this, governor can also appoint a state election commission. Now there's a trick here. UPSC might say that appointment of state election commissioner and appointment of chief minister comes under executive power of governor, and these positions are there on pleasure of governor. Now tell me that statement is true or false. Come on. Should I repeat, or you can pause and go back? I'm saying appointment of chief minister and state election commissioner are executive powers of governor, comma. These positions or these people serve there on the pleasure of president. So half statement is written before you and other half I have made up, that they serve on the pleasure of president, pleasure of governor, pleasure of governor I'm saying. Now tell me that statement is true or false. Pleasure of president is obviously wrong, and if I'm saying pleasure of governor, now tell me that statement is true or false. Some students would say, sir, it is correct, because chief minister is not having any secure tenure. Someone can be on this position of chief minister only till the point that person is having majority support in state legislative assembly. When more than 50% of the state MLAs are supporting that person as leader, then only governor appoints that person as CM of that state. Right? Now the point is, the moment that person loses that confidence in the state legislature, governor is going to remove that person. This may be after 6 months. So removal can be done by governor. It means this position is connected to pleasure, although condition is there. Till the point majority support is there with the CM, with the CM, then governor cannot remove that CM. Right? Now, what about state election commissioner? So twist is, when it comes to these positions, CM, council of minister, advocate general, they are there on the pleasure of governor. But when it comes to state election commissioner, so this position is not there as per pleasure of governor. Okay, so this is exception, and UPSC play on exception, right? So executive power, all executive actions of the government of state are formally taken in his name. As I told you, in the file, actions are taken in the name of governor. Now, what process is going to be followed while you actually approve these files? It can be decided by a governor on the advice of CM, council of minister, obviously. Appointment of CM ministers hold office during the pleasure of governor, as I told you in that question. So this is executive power. And what is this actually? Now council of ministers are appointed by governor, but which person is going to give in which ministry? How many ministries are going to be there? A sole power of CM, chief minister. Chief minister recommends to the governor and governor do that. Then in these states it was considered mandatory that tribal welfare minister need to be there. Chhattisgarh, Jharkhand, Madhya Pradesh, Odisha. State of Bihar was excluded from this list. Okay. Now second, emergency provisions. Article 356. President can actually, governor can recommend president rule in that state. So that is also what? Executive power, because law is already there. Governor is just executing that process. And if in this condition, means if these recommendations are accepted by president and president rule is imposed, now governor would be like, now extensive power is with me. Who is CM now? Right? So it means extensive executive power will come in the hands of governor if president rule is imposed. Then take information from CM regarding the legislative actions which they are planning, the bills they are planning regarding administration. Governor can ask CM. CM works as a bridge between Council of Minister and governor. You may have heard about some issue which was going on in Tamil Nadu, when governor actually took meeting directly with some district officials. So it was said that governor should not meet directly with district officials, governor should not question even the ministers directly, governor should seek information from CM. So this I have already explained to you. Advocate General appointed by governor, imposition of president rule, appoint state election commissioner. How state election commissioner is removed? The state election commissioner can be removed like the same manner on the grounds of judge of a high court. Such is the importance of state election commissioner. And why it is given? We are talking about democracy, and in democracy free and fair election is the primary feature. And how you can ensure free and fair election? The key official for in state should be the neutral one, should be free from any bias. So that person should be given this security. He can seek any information relating to administration. As I told you, seek information. This. So I think broadly, if you remember this, then it would be cakewalk for you. I hope it is clear to you now. Now attempt this question. Who can remove chairman of state public commission? Although we are going to discuss these later, but you should connect them simultaneously. Topics are interlinked. Yes, President, Governor, Chief Minister, Chief Justice of High Court. Some of you might be thinking, sir, remove chairman of State Public Service Commission. Okay, so State Public Service Commission, we are talking about state. So that person should be removed by governor, right? But that is wrong. Answer is president. Governor appoints chairman and members of State Public Service Commission. It is executive power, however, removed only by president. And question was asking, remove. So please remember, okay, appointment by governor, removal by president. Legislative power. So legislative power means power of governor with respect to house. Whatever happens in house, in this regard, governor is given certain responsibilities. For example, to call the session. Session will start only when governor summons the session on the recommendation of CM, Council of Minister. So summoning the session is legislative power of governor. Then governor is there to prorogue the session, same like president is there to summon and prorogue the session of parliament. Prorogue means end the session. Like I told you in President chapter, president is there to address the house in the first session every year, right? As well as after general election, first session, right? Similarly, at the level of governor, address the house in the first session, means after every year, as well as after new elections, right? Fresh elections. Send message to the house asking them that these legislative proposals are important, do please consider them. As well as disqualification. Yes, that is also legislative power. So in what case governor has power to disqualify? Whose disqualification we are talking about? We are talking about disqualification of state legislative assembly members, members of state legislature. As I told you in Parliament chapter, there are three broad categories on the basis of which a member of state legislature or member of even parliament can be removed. One category is mentioned in Constitution, other Representation of People Act, and third 10th schedule, that is anti-defection law, right? When it comes to anti-defection law, the decision to remove disqualifying that person lies with presiding officer of that house. For example, If you are talking about disqualification in state legislature on the basis of anti-defection law, then decision will be taken by Speaker of State Legislative Assembly. But when it comes to Constitution, Representation of People Act, where primary investigation is done by Election Commission, the Election Commission is going to recommend to the governor, sir, please remove this MLC. Then that is also a legislative power of governor. So please remember, appointment power in executive power, disqualification in this legislative power, disqualification of MLA. Okay. Now, presiding officer means who is going to be the presiding officer in case a speaker and deputy speaker of the state legislature are not there. So who is going to decide? Governor is going to decide. Similarly, there also president can act, although there is a panel also there. Ordinance making power is also legislative power of governor. Ordinance, what are ordinance? I told you, Article 123 in case of president, Article 213 in case of governor. In case either house of parliament is not functioning, it means there's no condition where this can be made, this important law can be made, since house is not functioning and there's immediate action which is needed. So this bill can be turned into a temporary law in form of ordinance by governor, right? So that is also legislative power. Nominate 1/6 member in state legislative council. Similarly, in case of president, 12 nominated members in Rajya Sabha. I hope you remember, right? Similarly here, 1/6. Now I think this will be cakewalk for you. Means this is what we have discussed, right? One thing you should remember, this is the same case. Promulgate the ordinance, but once house reassembles, you have to get it passed within 6 weeks from its reassembly. Same. Nomination, there is another condition called cooperative movement. It means 1/6 members are nominated from which category? Literature, science, art, social service, along with this cooperative movement. Okay. When a bill is sent to the governor, after it is passed by state legislature, he can consider bill is presented before governor. After it is passed by state legislature, what can governor do? Governor can give assent. Assent means now this bill will turn into an act. Governor can withhold. It means now done. This bill is not turning into an act. Governor can return. Means send the bill back to the house for reconsideration. But once house says, no, we are not amending anything, we are agreeing that this bill is correct, now governor has to sign this. Okay. Same as the case of president. Now there is additional fourth function with governor which is not with president, that is reserve the bill for president. So these are the 4 categories or 4 choices which governor has when a bill is presented before governor. I hope you will remember it. Now, financial power. This we are going to use also because now we are going to compare president and governor also. These things are going to get embedded in your mind, don't worry. Now, financial power. In case of president, I told you, budget is presented in Lok Sabha with prior recommendation of president. Similarly, in case of state government budget, it is presented in state legislative assembly on the prior recommendation of governor. So that is financial power. Like I told you, no grant, no demand can be made except on his recommendation in case of president as well as in case of governor. Money bill is presented in Lok Sabha with the prior recommendation of president. Similarly, money bill is presented in state legislative assembly on the prior recommendation of governor. He can make advances out of contingency fund. Similarly, we have contingency fund at the level of president also, contingency fund at the level of state also. Constitutes finance commission, but this finance commission is state finance commission. It is there to decide how much resources need to be distributed between state government and municipalities and these panchayats. Okay. Now I am asking a question and you have to tell me that statement is true or false. Finance commission. When I am saying just finance commission, it means I am talking about union level finance commission, which is actually constituted by honorable president. Finance commission can also recommend ways by which panchayats or municipalities should supplement their resources. Means finance commission at the center can give recommendations to state for enhancing the resources for municipalities or panchayats. Tell me the statement is true or false. Answer is true. Although we have State Finance Commission for that purpose, but Union Level Finance Commission can also recommend the same. Clear? UPSC has asked these kind of questions. Now, judicial power. I hope you remember in President chapter we discussed pardon, reprieve, respite, remission, right? Same judicial power are with governor, but there are some differences and their questions are asked. For example, take example that in case of death penalty, so president has power, this judicial power, to actually pardon death penalty. When I say pardon means absolving that person from any conviction. It is like ja simran ji le apni zindagi, no case, nothing, go home. That is pardon. When I say commute, there we discussed that now we are reducing the amount of punishment, right? So president can pardon death sentence, but governor cannot pardon death sentence. Okay, means governor cannot say a person with death sentence ja ji le simran apni zindagi, right? Cannot completely absolve that person from conviction, but can use respite and reprieve, these kind of things. Okay, another thing, with respect to court martial, president has power, this judicial power can be used, but in case of court martial means military court's decision, governor's actions are not going to be used. Okay, so these two differences you should remember. Apart from this, he makes so you can easily remember this. First of all, appointment and transfer in subordinate judiciary, it means district court, municipal court, right, session and the civil courts. So appointment of judges at this level is done by governor, obviously on the recommendation of State Public Service Commission and State High Court, right? Transfer is actually chiefly done by State High Court, but State High Court give recommendation, right? Governor do that. So prime power is with State High Court, but governor do that, right? So make appointment, posting, promotion of district judges in consultation with State High Court. Please remember, posting, appointment and promotion. Okay. Appoint person to the judicial service of the state, appoint. So just remember, appointment, posting, promotion. You can remember it like this. Remember this mnemonic: appointment, posting and promotion. Okay, postings means changing one position to other position, right? I think this is clear to you now. Now let's compare president and governor. So with regard to ordinary bill, if a bill is ordinary bill is presented before president, what choices president has? President can give assent, withhold and return. If it is returned once and it comes back again, then president is bound to sign. With respect to governor, governor has fourth option as well: assent, withhold, return as well as reserve. Reserve the bill for president. Now president has reserved the bill. Now governor has reserved the bill for president. Now what president can do? Means now this bill is reserved for president. Here is we have governor. Okay. Now what choices president is having? President can give assent. If he says assent, it means now this state bill can be turned into a law, right? Can return. Return means you have to return. Now when you return, there is a condition. Condition is that concerned state legislature has to consider this bill within 6 months time and send this bill back to honorable president. Okay. Withhold. So it means assent, withhold and return. So all three conditions which are with president in normal conditions are with president in case of reserved bill of state also. But here just one thing you need to remember: 6 months time is there with state legislature. In normal conditions, with the bill, when the bill is of parliament, means Lok Sabha, Rajya Sabha, no such 6 month condition is there. But on reserved bill, 6 months condition is there because this bill belongs to state. Clear? Please remember, when this reserve function is used by governor, now governor has no role with respect to this bill. This bill will directly go to that particular, means this bill is going to be presented in that state legislature, and when state legislature is going to send back, this bill is going to be presented before president. Now no role of governor in case of reserve function is used. Clear? With regard to money bill, what choices president has? President can give assent or withhold. Means president cannot return this bill because money bill is actually presented in Lok Sabha on the prior recommendation of president. Normally president gives assent to the bill. In case of governor, governor has three powers: assent, withhold and reserve. Please remember, one thing is common: return function is not used by president as well as governor in case of money bill. Return function is not used. UPSC is going to make statement on this. You need not to fall into trap. Okay. Now consider reserve function is used. President has sent. Now president is taking up this bill, state bill, as governor has sent this bill. Now what options president has? President can give assent to the bill. President can withhold bill. Return function, as I told you, is not going to be applicable in case of money bill. So the president cannot return money bill of for the reconsideration of state legislature. Clear? So please, it is quite easy now. And similarly, as I told you, once reserve function is used, governor has reserved the state legislature bill for the president. Now governor has no role. Now it is between president and that state legislature. I hope it is clear now. It is quite simple. Means while you are reading, it seems like so many words, but you need to just pick up the logic. Comparing ordinance making power of president and governor. Please remember, first of all, in which case ordinance can be used. If one house or both house, means either house is not in session, then president as well as governor can exercise this power of ordinance on the recommendation of prime minister headed by council of minister. Means council of minister headed by prime minister in case of president, and here CM, right, heading COM. He can promulgate ordinance only when he is satisfied that immediate action need to be taken. He is satisfied immediate action need to be taken, although works on the recommendation of council of ministers. So it is also same. So both is same. Now his ordinance making power is coextensive with legislative power of the parliament. It means ordinance making power of president is applicable on laws on which parliament has power to make law. Okay. Some of you might be thinking, sir, it is too obvious. Acha, it is too obvious. Let me ask one question from you. Ordinance making power of president is applicable only on union list. Now tell me that statement is true or false. I am repeating my statement. Ordinance making power of president can be extended only till union list or concurrent list. Okay. Tell me the statement is true or false. Some of you might be saying, sir, it is true, since you are saying can make law only on subjects where parliament can make law, right? Achha. I am reframing this statement again, and then I am going to tell you the right answer. Now the statement is, ordinance making power of president cannot be extended to state list. Means president cannot make ordinance on a subject which is mentioned in state list. Now tell me the statement is true or false. Some of you would say, sir, it is false, because it is clearly saying his ordinance making power is coextensive with the legislative power of the parliament. This means that he can issue ordinance only on those subjects on which parliament can make law, right? My friends, both the statements which I have made are wrong. Answer is false. Now some of you might be thinking, sir, then this is what is written here is wrong. Is Lakshmikant wrong here? No, Lakshmikant is right. You are wrong. You are misunderstanding. You are not listening to me. You are relating to things with your own preconceived notions. Let me prove you how. Here statement is saying president's ordinance making power can be extended only on those subjects, word only is used, only on those subjects where Parliament can make law, right? And the statement which I have made, in which I am saying only union list and concurrent list, first statement, that is wrong. The reason is, in special circumstances, Parliament can make law on matter mentioned in state list as well. And that is why both statements were wrong. Because Parliament can make law in union list case, in concurrent list case. But the statement was saying only, no, not only, because Parliament in special case, in a case of emergency, can make laws on matter of state list as well. So that is why in that case, ordinance making of power of president in that special case extend to state list as well. If you got it now, mention VA in comments, because I have saved you from a trap which UPSC is going to make in exam, and many students are going to fall in this trap, but you are not going to fall. Clear? His ordinance making power coextensive only extends to matter on which state legislature can make law. Should I play along this point as well? Chali, I am making another statement. A statement is, governor's ordinance making power cannot extend to union list. The statement is true or false? Tell me. Answer is true, because there is no case, no emergency case in constitution where state government or state governor can actually make law on a matter mentioned in union list. ये तो औकात से बाहर की बात हो जाएगी. That would be more, that would be way beyond the ambit of state legislature, right? I hope this is clear to now. An ordinance issued by him has same force as an act of parliament. Similarly, an ordinance issued by governor has same power as law made by state legislature. Ordinance issued by him subject to the same limitation as an act of parliament. This means ordinance issued by him can be made invalid. Means judicial review will be applicable here also, and judicial review will be applicable here also. Okay. Can withdraw ordinance at any time. Similarly, governor can also withdraw any time. Ordinance making power is not discretionary, has to act on the aid and advice of council minister. Similarly, not discretionary, has to act on the aid and advice of council of minister at state. Ordinance issued by him should be laid before both the houses when it reassembles. Same cases here. Within 6 weeks, same cases here. Within 6 means no instruction for the making of ordinance. In this case, instructions are that in case any bill which is presented before state governor by the council of minister of state, which has certain provisions in which this matter need to be referred to the president, then that matter need to be referred to the president. It means no ordinance should have provisions which are in conflict with central government. Now, pardoning power, as I told you, is applicable on central law, applicable on state law in case of governor. Only authority who can pardon that sentence is president, and governor cannot actually pardon that sentence, but governor can suspend, remit, commute that sentence. Means temporary. Suspension means temporarily, means now death penalty is actually delayed. That can be done by a governor. Governor cannot say ja Simran ji le apni zindagi or completely absolved. No. Can grant pardon, reprieve in case of court martial, but in this case no court martial. Means court martial case cannot be taken by governor, right? So I think it is clear to you now. The difference is clear. So these are just articles, you need not to cram them. These are some factual questions because we have played around the traps of this chapter. You are confident about it now. But UPSC sometimes are asking one or two statements on facts as well. Which of the following first Lieutenant Governor of Ladakh? Ladakh is in news. R.K. Mathur. First women Governor of State in Free India? Sarojini Naidu. Yes, this is a good question. Which one of the following statement is not true with respect to governor? Not true. They are part of state legislature. This is true. They can forgive the death penalty. This is not true. You got the answer. B is correct. Which of the following power is not vested in the governor of Rajasthan? So since Rajasthan governor was in news, so you should not think UPSC can play around this point, and some of you might think, oh, Governor of Rajasthan must be having some different power. That is why Governor of Rajasthan word is used, and that is not correct. Just read the statement. To summon the assembly, it is saying not vested. Summon the assembly, yeah, this power is with governor. Adjourn the legislative assembly. Adjourn power is not there, because adjournment power is with Speaker of State Legislative Assembly, right? Presiding officer. So it means this is the answer. Dissolution and prorogation are power of governor, right? So this is the answer. Second, I think that is correct. Now it is clear to you. So I hope now you are confident about governor chapter. If you find any difficulty, any kind of question, you can shoot me a message on my personal Insta handle, shashank.powerbeing. I'll be more than happy to help you out. This PDF will be available in the Shashank Tyagi for You Telegram group. See you in the next video.